The broadcast is now starting. All attendees are in listen-only mode.
Good morning and thanks for joining us today for our GDPR compliance webinar. My name is Shona Bradshaw. I'm the Marketing Communications Manager at Bytes Security Partnerships. I'm delighted to be joined today by Steve Marshall, who's the Executive Chairman for one of our core partners, Gettting. He'll be sharing a session today around the 12 steps the ICO recommends that businesses focus on to aid their journey to GDPR compliance. Just to give you a very brief overview of what we're going to be covering today, start with a little bit of housekeeping, and then a very short, I will keep it short, introduction to Bytes and Security Partnerships, as many of you do know us. I'll give a very brief background to why we're talking to businesses now and not at the end of the year about GDPR, and pass over to Steve introducing Gettting. Steve will then take us through the agenda for today, that's the crux of the presentation, around the 12 steps of focus that the ICO recommend businesses focus on. Very briefly touch upon some of the audit and assessment services we can provide before a Q&A. So just a little bit of housekeeping for the session today. Lines will be on mute throughout the presentation, and if there are any issues with audio or slides or anything, please do let us know via the questions in the chat box. I'll make sure that we address those as we go. As this is a live presentation, things can and sometimes do go wrong, hopefully not today. We will have a Q&A at the end, so please do post your questions via the chat or the questions box, and we will I'll be posing those to Steve at the end to make sure that the session's hitting your individual knowledge requirements. Point out sort of rules of engagement for today's sessions. We will be talking strategy and keeping to the subject of GDPR. We won't be talking massively about commercials or services on this session, though of course our account managers and your account managers will be delighted to have those conversations should you wish to do so after the session. We will have the recording available post-session. We'll be putting that on our website so that you can share that insight with your teams and provide that further within your business. And lastly, we do have a feedback survey at the end of the session, just to make sure that we're hitting the mark content-wise and presentation-wise. So if you could take the time to fill that in at the end, that would be much appreciated. So who are we? Who are Bytes Security Partnerships? So we are a security specialist and network security specialist reseller as part within the Bytes Technology Group. As such, we have been focusing on security for over 16 years. We're very specialist. We don't do anything but security, network security, content security. That allows us to build up a large and qualified in-house consultancy team. So we're able to wrap a suite of technology services, installation, support, around all of the vendors that we work with. We're very fortunate as part of that we do have top-tier vendor partnerships with the likes of Checkpoint, and we're one of only 3 4-star elite Checkpoint partners in the UK. We're a platinum partner with Forcepoint, who look after content and data security, an elite partner with RSA on the authentication side. What that means is we can offer not only commercial value to customers, but a lot of technical insight around the vendor and the technologies that we sell. Lastly, we have a full in-house support team, third-line qualified engineers, which have direct access to engineers. So we resolve about 89% of our support tickets in-house without vendor escalation. So that's just some of the ways that we add value to customers. So where do we work? So we work across network security, from firewall and endpoint, through content control and web security, antivirus, data classification, loss prevention. We also help businesses secure their mobility journey, and providing insight and logging tools, SIM, and authentication to make sure everything's security. Essentially, we are securing business enablement, and that's what we do within the Bytes Group. So what do we offer? Very briefly, so we have accredited consultants, technology delivery, in-house support. We offer a full suite of services around scoping, project planning and delivery. We offer strategy development, technology mapping and knowledge transfer and training. So we do have a full suite of services to enable your in-house teams to grow and make the most of the technologies that we work with. So on to GDPR, that's enough about us. Why is GDPR a game changer? Just a few points from conversations that we're having with customers. Firstly, it not only exists and tightens up the existing Data Protection Act, but it also adds completely new obligations for businesses, and some of those are quite far-reaching. Steve will go into some of that later. An example of this is some of the need to appoint a data protection officer, the need to be able to control and manage data not just held in-house, but extending into the cloud as well. And so those are really key things that aren't covered as specifically in the existing Data Protection Act. It's extraterritorial, so even if your business is not within the EU, if you hold EU citizens' personal data, the GDPR trumps your national laws. So it will affect the UK, regardless of in or out of a Brexit, and it will also apply prior to the UK leaving the EU. So we will definitely be moving on to GDPR from May 2018. The fines are scary, quite frankly. Up to 4% of global revenue. So for a small company within a large group, that can be business critical. So it's up to 20 million euros, or 4%, whichever is greater. And the other reason we're talking to people about GDPR just now is it's a piece of legislation where IT security, legal, operations, and all the other departments need to work together to ensure compliance. And that takes time. That's why we're speaking to you about it now. So essentially, the whole rules are around the right to be forgotten, the need to obtain consent. That all is a process which, in order to comply, again, takes time. And Steve will walk you through some of the more detailed insights into those two areas later. And lastly, to say that there are no silver bullets. There are very different methods and technologies that can be used to aid in GDPR compliance, but it starts off with actually understanding the legislation and forming an individual plan for your business around that. So, without further ado, I'll introduce and hand over to Steve Marshall. He's the Executive Chairman and founder of Gettting. They are a global provider of advisory, audit, incident response and digital forensic services. And we've asked them to join us today, so they have extensive current experience working with UK companies and groups to ensure not just compliance with the EU Data Protection Act, but also our current DPA. They're PCI, expert witness and CREST certified, so provide a lot of the actual technical and detailed insight into GDPR and how you can comply and ensure that your compliance models are strong and will stand the test of time. So I'm going to hand over to Steve, who will talk to us specifically around how to understand the regulations from an official perspective and what we can learn from that guidance. Thanks very much, Steve.
Thanks, Shona. Hopefully everybody can hear me. Good morning, everybody. I realise that some of you have probably just said good morning to your screens and I can't hear you because obviously you're on mute, so I'll just accept the fact that you've said good morning. Today what I'm going to do is focus on the 12 steps that the ICO recommend that you take now. These are the things that the ICO has said from the Data Protection Act as it is today, the things that you need to look at and consider in order to get yourself ready for the coming GDPR requirements. So, if my screen will work, which it will, why change the legislation? So I'm just going to run through a little bit of background as to, why change the legislation. Well, as we all know, there have been quite a few data compromises over the last 4 years. I know that this is kind of a bit like snake oil in reality. A lot of the information that we see comes from the US, and a lot of that is specifically because of the fact that there's breach reporting notification in the US, which there isn't within the UK at the current time, although interestingly, with the changes with the GDPR coming in, breach reporting is likely to be mandatory. There are certain tests and conditions, but these things are likely to move through the process in the longer term, where breach reporting will be mandatory to the ICO, and the likelihood is that if breaches are reported, they will be notifiable on their website. So what you'll see is that over the years, breach has increased and the number of records breached is increased. Last year specifically, the numbers suggest anywhere between about 1.6 and 3.1 billion records being leaked. So obviously people, are motivated, they want to do something about it. Now, a lot of the things that we see in terms of data losses and the responses, you'll see on my slide, most people suggest that they were the victim of a very sophisticated attack. They couldn't have done anything about it. They couldn't have seen or prevented the attacks, but they do take security seriously. The problem that we have is, as investigators, we investigate probably about 70% of all credit card fraud in the UK, and we do a number of other investigations for businesses around IPR and these kind of things. What we find is that really and truly, most breaches that occur are very unsophisticated. We find that things like, had you put antivirus on software on your web server, the attacker wouldn't have been able to upload a web shell or inject a particular malware in order to extract data from you and steal credit card data and these kind of things. Very, very, very simple attack vectors. I was in a customer the other day and doing some social engineering for them, and literally walked in and said, "Oh, I forgot my pass." Wouldn't you believe it? I'm the new director of audit. I've left my pass on my desk. I'm going to get ribbed quite a lot by my other directors. I'm really quite embarrassed. And the lovely cleaner came up to me and said, "Oh, would you like to get through there?" I said, "Yeah, that would be fantastic." And she opened the door for me and I walked in. It really is that simple. Just as you'll see on this on this slide, we have electronic door locks, 4-digit PIN codes, where you can see actually the digits are worn. It's that easy in order to get into a lot of companies. So everybody wants to do the right thing in terms of business. Everybody wants to, ultimately protect data of their customers and these kind of things. Unfortunately, what seems to happen is that other priorities tend to get in the way, like making money or offering new services or moving solutions forwards in order to give people the things that they actually want. So one of the things that we've seen over time is that actually, businesses need to be incentivized in order to make changes, whether it be regulation like GDPR as it will be coming, or contractual obligations that are placed on them like PCI DSS. Now, in terms of the fines, there are very strict criteria in order for the ICO and the other supervisory authorities in order to be able to give you a fine. However, there are other things that they have the opportunity to do. They can stop you processing data. They can put undertakings on you in order to monitor your progress and how you do things, and a whole bunch of other stuff in order to look at controlling what you do and how you do it if you get it wrong. So it's very important in terms of understanding what the requirements are, what's going to need to happen. Unfortunately, you're not going to be able to bury your head in the sand with a lot of these things. It's coming, it's regulation, you are going to need to do it. So that's the kind of fun and interesting stuff out of the way. Unfortunately, it's now down to the boring stuff that I can't do anything about. So unfortunately, I'll crack on and go through the 12 areas. These are the 12 areas that the ICO has put up on their website, and there's a very good paper on there that gives you some very basic information in terms of these 12 areas that are significant and will be significant to your businesses in terms of what you need to focus on right now. Obviously, the legislation is broad, and it was written by a German lawyer. It is very standardized and very efficient. as you would expect. However, it is also complex, and it's going to cause lots and lots of issues when you get down into the real nitty-gritty of these requirements. So, first area, awareness. GDPR, as like most things in your organisations, only work top-down. If the exec are bought in, absolutely, you will have support through the process. You're going to need their support. You're going to need time, you're going to need money, and you're going to need resources. Like any big change, program of works, or any projects that you run, you really will need time, money, and resources in order to make sure that you can actually deliver what needs to change. Execs also need to be aware of the consequences. There are consequences in terms of all of these things: monetary penalties, undertakings by the ICO, containment audits, external audits. They can restrict your processing activities in terms of the data that you process. They can order you to delete data. They can stop you from processing entirely. They can force you to change your third-party processors. All sorts of things are allowable within the legislation itself, and your execs need to be aware of this. Now, just like the DPA, there is no sanction within the DPA directly or within the GDPR that allows execs to go to jail. However, just like the DPA, there is other legislation that can put your execs in jail, and as with the current DPA, Section 55 breach allows for other legislation to be used in order to look at these things, and I'll give you some of those. Criminal Justice and Immigration Act of 2008, RIPA of 2000, which has now been replaced, Computer Misuse Act, Fraud Act 2006, Bribery Act 2010, and Misconduct in Public Office. Now they suggest that that's a common law offence rather than actual criminality, but that's politics for you. Now, just to say, I'm not a solicitor, I'm not a lawyer, I'm not legal counsel or any of these kind of things. I'm an information security specialist, so I can't give you legal advice. What I can do is comment on the information that the ICO provides, and solicitors and legal counsel that I've worked with have provided to me. So this is the context for what I'm going to cover. Make sure that you do talk to your execs and they do understand the requirements and the nature of this regulation, so that you get that support that you require. Information you hold. So you're going to hear lots and lots about technology that can solve your problems with GDPR. It can find your data, it can search and index that data, it can help you anonymize it, and all these kind of things. And that's brilliant, okay? All of those things are going to be useful to you. However, it's not the whole story. What you do need to remember is that actually you need to know about your business processes as well, and you need to map those. You need to know where the data comes in, you need to know where the data goes out, you need to know which third parties you're using, you need to know if those third parties are also using third parties. So you need to know things like your contract chains, who's processing what, how they've got access to it, where they've got access to it, how you hold that data, how you process it, what you do with it. So it's very important that you remember to look at the actual full business process and the full processing chain that you have to see where that data goes through the process. You also need to remember, I know there's some people on the webinar today that work for legal firms and these kind of things. Just remember, just because you have hard copy material, if it's indexed, it's got personal data in it, the GDPR is going to apply to your hard copy material just as it is to your electronic material. Okay, so you don't get out of jail free by moving your business to paper if you can find data in an index system. Okay, so it's very much the case that the GDPR will cover all of these things, and it's very, very important that you do a data audit. It's very important that you know the business processes and the third parties with access and those kind of things as well. Okay. The other interesting thing is that if you're a processor, you're not off the hook anymore according to the GDPR. The GDPR applies equally to processors as it does controllers. So that means that if you're a processor and you have a breach, you're in the same situation as a controller that's had a breach under the GDPR, and the same sanctions apply. So even as a controller, if you outsource the responsibility for processing, you will still be accountable and liable, and if you are a processor, you will be accountable and liable as well. Communication. Now this is an interesting one. In terms of communication, it's about what you tell people when you actually acquire their data. And what you'll see on this slide is there's two areas. Data obtained directly from a data subject and data not obtained directly from a data subject. So i.e. this is where your third parties and you gain data from from third sources or from these companies that say we will share your data with our selected third parties that may offer you goods and services and those kind of things. Now what you'll see is there's quite a lot of things in terms of your requirements that you need to tell your data subjects when you obtain data from them, or if you get it from a third party when you communicate with them. Now the thing about communication is that there is lots more things that you need to tell people about their rights, and you need to do it in a clear, concise and transparent manner, which means you have to tell them who you are. You have to tell them if you've got a data protection officer, you have to tell them who that is. You have to tell them what data you're going to use. You have to tell them why you're going to use it and what the legal basis for that processing is. You need to tell them how long you're going to retain it for, why you're going to retain it, and you need to tell them what their rights are. So for things like consent, if they give you consent to process their data, you need to tell them that they have the ability to withdraw that consent at any time. They have the right to lodge complaints, who the supervisory authorities are that they need to speak to in order to make those complaints. But interestingly, you also need to tell them if you're going to make any automated decisions about them. So if you're going to process their data in an automated way to make a decision, you need to tell them what that is, and that they have the right to object to that automated processing such that they can get a human to look at it if they believe that the data has been processed inaccurately. Now, if you get this data from a third party, what you'll see is that on the right hand side there's a tick in the box that says the source the personal data originates from, whether it came from publicly accessible sources. So if you get the data from third parties, you will need to tell people where that data came from, or whether you sourced it from the internet or other public information that is available to you. Okay, and also you need to tell them, obviously at the time you collect that data or at the time you're specifically using that data, or if you get it from a third party at the point of communication or within 1 month. So lots of rights have changed. Lots more rights are changing in terms of the individuals and what they have access to, and you'll see on this slide, there's 8 rights that they're given. Now, with all of these things, you have to look at being proportional and being appropriate in terms of the individual's rights. Okay, these rights are for everybody within the union. You have the ability to safeguard your personal data. However, these rights are can be overturned, and they can be mutually exclusive in terms of the requirements. What you need to look at is really and truly what the GDPR is getting you to look at is why you're processing data, what you're processing, making sure that it is accurate, that people are informed about what you're doing, why you're doing it, and you're doing it in line with both their rights and the law. And that's really what all of this comes down to, is that, you know, their rights have to be protected. However, they are not absolute rights in terms of these things. So for things like detection and prevention of crime, the GDPR may not apply in certain circumstances for, you know, legal processing, and I'll come on to, you know, some of the things around consent in a couple of slides' time, in terms of the reasons that you would give consent and why you need data. So I'll go through these. The right to be informed, we've just discussed that in terms of that's communication and how you communicate with people and what you actually need to communicate with them. Remember, it has to be clear, it has to be transparent, okay? There's no more of this silence equals consent anymore. You know, people have to take affirmative, definitive action in order to agree and consent, and I'll come on to some of that shortly. The right of access, well, I'll discuss that in the next slide. That's about subject access requests, or SARs, as some of you will know. The right to rectification. Now, this is a very interesting one, is that people have the right now to have their data rectified. They did under the Data Protection Act. However, there's now a lot more requirements in terms of the GDPR. So if a data subject contacts you and says, my data is incorrect, it needs to be rectified, here's the appropriate data that you need to rectify in order to correct an inaccuracy, you are obligated to do that within a month. That can be extended by up to a further 2 months, but you must communicate with the data subject. And you can only extend that by 2 months if it's a complex requirement, okay? So one of the things that this is going to generate, and you'll see later on, is that one of the things under the GDPR is they want to move people towards best practice, which is actually putting a lot more responsibility and access into the hands of the data subjects themselves. And one of the things that, you know, is best practice at the moment is actually giving data subjects the ability to curate and change and modify their own data in order to keep it up to date. And I'll talk a little bit more about that later. The right to erasure. Now, this is an interesting right. It's sometimes called the right to be forgotten, and it's there in order to allow data subjects to be able to say, right, you finished with my data, please erase it. Now, interestingly, on this subject, under the GDPR, you do have the ability to be able to keep data. So if I was to say to a marketing company, okay, yes, I don't want to receive your emails anymore, please erase the data that you have on me, it's absolutely feasible and right for them to be able to keep enough data to be able to ensure that they can prove that they're no longer processing my data. So what does that actually mean? Well, what that actually means is they have the ability to be able to keep my email address, to be able to say, right, do not mark it to this email address because they've requested to be erased. However, what it doesn't do is give them the ability to be able to keep other data that they may have on me, like my name or my address or my telephone number, if they don't do any mailing marketing or telephone marketing or those kind of things, and it's only e-marketing that I was getting by email. They have the ability to keep enough data to show that I have been erased and that actually they can prevent future marketing to me. The right to restrict processing is similar to the right to erasure in terms of it allows both companies and data subjects to actually block or restrict processing. So rather than be erased or forgotten, a data subject may decide to actually, yeah, they don't want emails for the next 3 months, but they do want them post that time. So what they can ask you to do is restrict the processing that you do on them for a period of time, and then to start the processing again. And again, that's about communication. It's also about talking between both parties in order to say, yeah, this is what we're going to do, this is how we're going to do it, this is how it will work. Okay, there are numbers of other examples in terms of restricting processing, and that's a decision that can either be taken by the processor or the controller, but it's also a decision that can be taken by the data subject. The right to data portability. Now this is a very interesting one, and one that there's a specific paper that's been written by the Article 29 Working Party, which is the collection of the information commissioners and their representatives that have gone through the legislation and are looking at specific pieces of the legislation. Now, do we have all of the information at the moment? No, there's still a lot to come. Okay, one area that has been clarified is the right to data portability, and what this says is that actually, as a controller, the data subject has the right to ask you for their data. So I'll give you some interesting examples. Okay, so I'm an energy utility company, and you buy energy from me as a data subject, so I need to collect certain data from you, your payment details, your name, your address, these kinds of things, in order to be able to process a contract with you in order to supply you energy for your house. However, what I've also done is given you a smart meter in order to measure your energy accurately. Now, interestingly, the right to data portability, if the customer decides that after my 12 months contract is up, I actually want to move my service to another provider, I absolutely have that right. I can do that as a data subject, but what I can also do under the GDPR is ask the controller to give me my data in a common, usable format that I can take to another provider. So for instance, I can ask them to give me all my own personal data back, but also data specifically that relates to me. So if I want the raw data from my smart meter, I am allowed that data, and under the data portability requirements, you as a controller would need to give it to me. Now this is going to cause quite a lot of issues in terms of how you actually get that data, where it is, what those portable formats are, and how they're transferable. Now, this is where there are some examples in the UK. So if you look at my data in the UK, it was something that was set up quite a few years back now in terms of the banking industry, and there are very specific codes of conduct, but what it does is it covers things like data portability formats, it covers interoperability formats, and these kinds of things. And what it's allowed is it's allowed the fact that as a consumer, you should now be able to seamlessly transfer your bank account and direct debits and these kind of things from one banking provider to another. The idea behind data portability is that you should be able to use things like comparison websites in order to be able to take your data from one provider in a format, put it into a comparison site and look at, am I getting the best deal? Can I move? If I do move, can I provide the data in a way to my new provider that allows me to get accurate information on usage, accurate information on costing, so that I can then go to a provider that gives me the best deal. And that's what this data portability is about. It's probably one of the areas that's going to cause a huge amount of change and a huge amount of issue to lots and lots of customers. The right to object, as it says, you need to tell people that they have the right to object. They have the right to object to you based on the processing that you do on them if they believe it's unfair or unreasonable, but also they have the right to object to a supervisory authority. Now, whether that be yours or whether that be theirs, they can do both. Right in relation to automated decision making and profiling, so for instance, if you use automated processes within your business to make decisions about people like credit vetting, for instance, or these kind of things, people need to know what they are, people need to know how they work, and absolutely, unfortunately, under the rights that the individuals have, you have to tell them how those solutions work. Now, everybody's going to jump up and down, and I can hear the lawyers in the room shouting intellectual property rights at me, copyright, trademark, and a whole bunch of these things. Unfortunately, what the GDPR says is you do not have the right not to give people information on automated decision making and profiling, even if that includes intellectual property, things that you have under trademark, or these kind of things. What it does do is it does place rights onto the data subject to say you may not use the information that you are given by these companies, you know, for your own gain or for the gain of others, because that would be fraud and covered under the Fraud Acts. But what it does say is that you do need to give them that information. Now, it's going to be interesting because I'm sure that at some point that will be challenged in court, because if, you know, it's very much companies do not want to give away things like intellectual property or the decisions that are made and those kind of things. And I'll come on to subject access requests because this is where a lot of this is covered. Unfortunately, you do have to give up this information, and objecting based on intellectual property and those kind of things is specifically covered within the GDPR, and it says you can't. Now, you can't charge for subject access requests anymore. There is no charge available. You have to do it within 30 days rather than 40, although you can extend by a further 2 months if it's complex or numerous requirements. You can only refuse a request if it's excessive, unfounded in terms of it being repetitive or overly prejudicial or these kind of things. But the burden of proof is on you in order to prove that in court, ultimately. You have to identify the individual making the request, i.e. you can't just give it to people as you do today, you know, in terms of the Data Protection Act. The same things will apply, you know, usernames, passwords if they're using automated means, or things like your data protection checks that you do in terms of identifying the person you're talking to on the end of the phone. If the request is electronic, you need to respond as such in a common format. And as I was talking about, best practice says you should provide secure self-service direct access. Now, this is one of the areas that's going to benefit a lot of the larger companies that are on the webinar today or listen to this, is the self-service piece. Now, ultimately, yes, you know, it's a lot of money in order to get to the point of true self-service and these kind of things. However, if you get huge amounts of things like subject access requests or data portability requests or these kind of things, yeah, unfortunately, you're going to need to be able to respond to them, and you're going to need to be able to respond with them and not charge for them. Therefore, you know, one of the things that companies really need to look at, especially if you're dealing with large volumes of data, is the secure self-service route in order to get the data subjects themselves to curate their own data, ensure that it's accurate, deal with the data portability requirements and subject access requests, because their data is in one place. Now, I get it, everybody's going to be shouting, yeah, but we've got legacy systems and we've got this and we've got that. Absolutely understand. Unfortunately, legislation and the German lawyer that wrote this really don't care. It's one of those things that they've said, this is legislation, you'll meet it, it's going to be difficult, challenging, tough, complex. Absolutely understand. Legal basis for processing. Now, I'm only going to cover the top 3 here. Consent, that's where somebody says, absolutely, I consent, you can do this. Processing for the performance of a contract, i.e. you need to process a credit card fee, or you need to do a credit vet, address check, age check, something like that. Processing is necessary for compliance with the legal obligations. So these are things like anti-money launderings, the AML regulations, KYC regulations, these kinds of things. And they're the 3 that most of the businesses are going to see. The others you're going to see in councils, and you're going to see in police and local authorities and universities and those kinds of things. Consent is one of the things that you are going to need to prove. So you are going to need to be able to prove that somebody has given consent for what you're doing and how you're doing it. Consent under GDPR, requires clear affirmative action. Silence and pre-tick boxes or inactivity doesn't give you the right to use their data. It must be unambiguous, is what it says. It must be verifiable. You must be able to prove it. Okay. The GDPR is very much about proof. You have to be able to show what you've done all the way through the process, and it's one of the things that the ICO will look for is proof. Children, I'll touch on this very briefly. If you're providing services to children, the bar is a lot higher in terms of what you must prove, and ensure that your privacy notices and these kind of things are written clear, plain ways that children can understand. Now, the age of consent is an interesting area. GDPR considers it 16, although it's one of these areas that is changeable down to the level of 13. So far, the Information Commissioner has suggested that they will have the age of consent set at 14, so under 14 will require parent or guardian's consent. Over 14, the child will be able to consent in their own right. The reason for 14 is so it's in line with the US legislation, because the US sets the bar at 14, and it just allows easier services like Facebook and other what they call information society services to be provided across the ocean. Data breach. Now, obviously, this is a very interesting area, and an area that is going to become a lot more relevant in terms of all businesses. So at the moment, very few businesses have to notify on a data breach to the ICO. There are specific regulated businesses that do, most don't. However, if the breach is likely to cause distress or damage to a data subject, then you have to report it. Okay, it's very much the case that you don't have to report everything in one go, i.e. the ICO is not going to expect you to have the case sewn up within 72 hours, all of the information into them and on their desk. What they will expect, though, is that you notify them that you believe that the data has been compromised, or data specifically to data subjects that is likely to cause distress or damage, and they will then expect regular updates, and they will probably place undertakings and requirements onto you in terms of what you need to provide and when you need to provide it. Okay. The other things are that they can also, if the damage or distress is likely to be significant, they can also require you to notify the individuals that this has occurred. Now, obviously, this raises a huge amount of interesting areas in relation to, well, if you notify a data subject, are they likely to leak that to the press? Is it likely to become open and known? The answer is probably yes, in terms of, you know, the ICO will have the right to publish it on their website in terms of the damage and scale of the problem, and also then place undertakings on you in terms of those things. Now, you know, there's no such thing as a good breach, but actually planning appropriately, understanding what happens and reducing your likelihood and risk by complying with the areas of the GDPR is likely to make things less problematic for you. Protection by design and default. So this is very much about understanding what you do and how you do it, and when you change things, how is that going to affect data? So we all know that generally, as businesses, we have a good handle on things like our CapEx projects, because they're big things. They go through our governance regimes. You know, we see them within our program or project management offices. They're considered and this kind of stuff. What about things like your OPEX projects, where marketing have got an OPEX budget and they decide to, you know, put some new technology in, or fiddle with the structure of the marketing database, or these kind of things? Well, one of the things that GDPR is fairly hot on is making sure that data is protected appropriately. Now they say by design and default, so what they want you to get to a position of is that actually you understand where your data is and what you do with it. Therefore, when you change anything, actually what you do is you consider the impact. Now, data protection impact assessments, or DPIAs as they are, only actually need to be used for new technologies or processing that's likely to result in high risk. What I would say to you, and the advice I would give to you is, yes, absolutely, you're going to need to go through a data privacy impact assessment for those areas. However, if I were you, what I would do is I would use the data privacy impact assessment for all of the changes that I do in terms of any change to privacy data that's going to have an impact. So if I'm going to patch a server, all right, yeah, I probably won't use it. However, if I'm going to change the process, or I'm going to change the team that does it, or I'm going to put a new piece of technology in, or I'm going to change the way that I process by making it more efficient or something like that, then absolutely I would recommend using DPIA, because what it's going to do is it's going to say, right, what am I doing? Why am I doing it? What's the impact going to be? What are the risks to the data? So I can look at the risks to the data and say, do I need to change the way I protect it? Do I need to change the process? Do I need to do something differently? Or is it absolutely acceptable in order to be able to do that? Data protection officers. Now, this is an interesting area. If you're a public body, or you carry out large-scale monitoring or processing of special categories of data, you have to have a DPO. However, what the GDPR says is that whether or not it obliges you to appoint a DPO, somebody has to have the sufficient skills and ability to effectively act as a DPO within your organization. Now, you need to be careful about the term data protection officer or DPO. If you call somebody in your organization a DPO, they have governed and specific rights and requirements. So think carefully before you appoint one. However, ultimately, you're probably going to need one. Now, DPOs are an interesting category. You can't fire them for doing their job. Okay, it's you can fire them for other things like gross misconduct and that kind of stuff, but actually you can't just fire them because you don't like what they're saying to you. And that actually is a specific requirement if you call somebody a data protection officer within your organization. They have to report to the highest level management. You can't have them reporting to the cleaner. They have to report to a director and a board level director if you have one. They need to be able to act independently within the organization. So what this is going to do is it's going to cause a lot of changes inside organizations in terms of how they do things and what they do. And actually, it's going to be one of the biggest areas, I think, of change in terms of lots of organizations. One of the things that I talk about in terms of structure inside companies is what's called business integrity, and it's one of these lovely departments that companies really should form, because it allows them to lock all these people in a cupboard down the hallway and forget about them until they pop out their clipboard and start doing audits. And for me, that area encompasses things like corporate and information security, audit, fraud, data protection officer, compliance, governance, all that kind of lovely stuff that nobody really wants to do. Stick it in one department and let them get on with it. It's actually quite a good way to give yourself some integrity around your business. Now, normally the best place to put them is under legal, and get them to report through the company secretary into the board, because it gives them a nice ubiquitous reporting line straight into board, just in the same way as you do with finance. You don't have finance within the different departments. They have a ubiquitous reporting line up through financial controllers into the CFO, into the board. Again, it's exactly the same with these things. What they want to see is independence, and what they want to see is people being able to work independently without fear of, you know, IT or operations or these kind of things within the business, being able to veto what needs to happen and stop people saying, no, you can't do that because you're just going to release 400,000 you know, people's personal details onto the internet. So there's a lot of change around DPOs. So think very carefully before you appoint one. Whatever you do, you're going to need one way or the other. I'll touch on international very quickly. If you operate internationally, you need to know which supervisory authority you fall under. Now, generally, this is quite easy. If you're a standard hub and spoke, if all your decisions are made at the hub, you'll be under that supervisory authority. If you've got lots of different things processed in different areas, lots of different decisions made in different areas, it becomes very, very difficult to work out which supervisory authority you're actually under. Map it out, map out what you do, who's got responsibility, who's able to make decisions ubiquitously about what happens with data, and if you're in any doubt, speak to your local supervisory authority, speak to the ICO in the UK if you're a UK company, in order to make sure that you've got you're under the right supervisory authority. They should all act the same. However, be advised that supervisory authorities will expect to speak to you in their own language and with their own requirements under their own local laws, as well as the GDPR. So just be careful where you've got your operations and you have people that are able to do that. I thought you'd all be bored, so a little bit of origami never goes without fail. So, in summary, last slide, I'll shut up, you can ask some questions then. I understand it's probably been a bit boring for you and my voice has got very monotone, and it's usually a good cure for insomnia. Look at your business, look at your IT, make sure they're aligned, okay? Use good frameworks. Currently, there is an ISO standard for GDPR and privacy. It's ISO 29100. What it says in the back of ISO 29100 is you can use ISO 27001 and just change the word asset to privacy asset, etc., etc. It's the standard we use personally for a lot of these things. It's a very good place to start in terms of being able to draw together business requirements and IT requirements. What it also requires is senior management engagement in terms of doing these things. Therefore, you know, it gets you into that awareness piece as well as sign-off resources, support, budget, and those kind of things. So it's a very good place to start. You have to be able to demonstrate compliance with GDPR, and it is possible that the ICO has the right to audit, and they have the right to walk in and ask you in order to show how you comply, and the burden of proof is on you as the controller or as the processor. Make sure you map your processes, know where your data is, communicate clearly with individuals. Okay, this is going to be one of the biggest things. You can't hide behind fancy lawyers and fancy words and things people don't understand anymore. It has to be clear and understandable, because if it isn't, data subjects have the right to complain, they have the right to object, and they have the right to refer it to the ICO for them to look at. So communicate. Codes of conduct, this is an interesting one. Lots of areas of business have, you know, have communities, and they also have guilds, and they have you know, collections of interested parties and these kind of things. Look out for the codes of conduct. There's a bunch that are going through with unions and all sorts of things at the moment. They'll be coming to the ICO's website, and they may cover some of the areas that you operate in, or the actual areas that you operate in through professional bodies and these kind of things. And I know there's a lot of collaboration going on with professional bodies at the moment around some of the codes of conduct. Look out for them. They're going to be very good. Change your departmental structures, make sure you're aligned appropriately, conduct your third-party due diligence, make sure you've got good legal counsel. This is a good one. get good advice, whether it be from people like me that have done privacy for a long time in terms of the information security aspects, but also good legal counsel in order to check that you're doing the right things and complying with the law. And then align your IT, get the basics right. You don't have to outrun the lion. What you do have to do is outrun the person next to you so that you don't become the next breach victim and end up with the ICO giving you an undertaking or stopping your processing. Some useful links, it will be in here so you can look at it. And that is me done, so I'll pass back over to Shona and take some questions for the last 2 minutes.
Thanks, Steve. Hopefully you can all hear me. So I have some questions from the audience already. If anyone else who has a question would like to take time to type it down over the next couple of minutes, we will answer as many as we can. So I have one from you regarding communication. Do the same rules apply for data collected pre-GDPR? So do businesses have to retrospectively go back and obtain the necessary consents, etc., for data already collected?
Okay, good question, very good question. The answer is yes and no, and I know that's my usual standard consulting rubbish answer, but what I'll do is I'll clarify it for you. If you have the appropriate evidence that you have the consent to use that data, no, you don't have to go back and communicate with the with the data subjects in order to regain consent if you are processing in line with what you have consent for and you have the appropriate evidence. However, if you don't have the appropriate evidence in order to show that they gave you consent, or that you've communicated your requirements, the terms and conditions, how you're going to use data and these kind of things, absolutely you will need to. What I would say to you is that the GDPR is about transparency and it's about communication. Make sure you do communicate with people, and it's a good idea to start pushing some of these things through your processes now in order to look at how you make things more transparent, what information you give them. If you're getting consent in terms of things like contracts, for instance, so you're taking money from them in order to provide goods or services, absolutely, you can update as you go through the process and draw their attention to the, the new consent that they're giving. What won't be acceptable is, the things like Apple and this kind of stuff have today, which are, 60, 70 pages long of very small text that I know all of you read every single time you agree, and it's exactly the same problem you'll face.
Okay, and then I have a similar question from a retailer. If they implement customer profiling algorithms on data already collected under GDPR, do they have to contact the affected customers to tell them of that new process?
This is customer profiling is also a very interesting area, and there's quite a lot of information on profiling specifically. The answer is, again, it depends on what consent you have and whether what you've told them you will do with that data is in line with the consent that you have. That's the first thing. Second thing is whether you can identify the individual from the data that you have, or whether you've anonymized it or pseudo-anonymized it, for the purposes. If you're using it for your own reasons in order to be able to provide better service to customers and this kind of stuff, you need to look at what you're doing, why you're doing it, and how you're using it. Do you specifically need the personal data, or do you need the information for things like historical reasons, archiving reasons, and these kind of things? It's an area that will take quite a long time to answer, because depending on the inputs that you put into that, depends on what the GDPR actually says, because there is there's a large number of sections around profiling. What I would say though is, if you've got consent, you've got proof of consent that people have opted in and allowed you to do that, or you've appropriately anonymized the data and you're using it for profiling and historical reasons, yes, you can do it. It can do it for the reasons that the controller requires it. However, it depends whether you've got proof, and that's really going to be the interesting point, is whether you have enough evidence of proof.
Okay, super. So I have another question here. It's a $64,000 question, really. How can businesses emphasise the threat to their executive teams that have had little exposure to the ICO and DPA historically, and therefore review GDPR risk as low?
Yeah, it's always one of these questions. I mean, you know, what you'll see is you need to know your exec is the answer. Okay, some respond to, you know, threats to personal liberty. Some respond to, you know, having to, if you're a PLC and you get a very large fine, you know, notifying shareholders in the city. You know, it really does depend on your exec and the sector that you're in. What I would say is over the years of doing this, you know, I've found a number of different things have worked. Some exec are very, very sensitive in terms of business reputation. Some are very sensitive to, you know, monetary penalty. Some are very sensitive to, you know, freedoms and liberties. However, most just don't understand, and a lot, you know, all they see is that, you know, things like security get in the way of them doing business. It gets in the way of you know, being able to service customers and make money. Ultimately, what you need to do is educate them to understand that actually, yes, there are things that will get in the way. Undoubtedly, yes, there are things that are going to have to change. However, if on May 18 you have 2,000 subject access requests that you have to process within a month, guess what? You're going to have to process them within a month. And whether you like it or not, tough. You're going to have to process them within a month. Therefore, I think a lot of the things that will happen is it depends on how your customers view you as a business and those kind of things. If you've upset or annoyed customers over a period of years, they're absolutely going to access excuse me, they're absolutely going to access their rights as data subjects in order to put subject access requests on you, because you can't charge for them and you have to respond within a month, right? You know, these things are going to happen, and people are going to exercise their rights, and if they don't, and if you're not able to comply with them, they will complain. And then the worst thing that will happen is the ICO will walk in and place undertakings on you and could potentially tell you to delete the data and close your business because you can't process PII anymore. It's very much about finding the key pressure points within the exec and what motivates them and what places them at risk, and talking to them in terms of reality.
Okay, so I have another question. Just a bit of clarity, is there a specific date by which organisations need to be fully compliant?
So, yeah, this is another very interesting question. The regulations come in May 18. Okay, within the back of the articles, there are a number around things like certification and certification marks of compliance and these kinds of things, in order to show, yep, we are fully GDPR compliant, and each individual territory, you know, has the ability to be able to put in certification schemes and the ability to demonstrate compliance. Is there any further information other than what's written in the GDPR at the moment? Not that I've seen. I've not seen any national compliance solutions that say, you know, unlike ISO 27001 where you can say, okay, right, I get myself ready, I'll do all my paperwork, I'll go through my containment audits, I get everything in place, I'll then get a certification body in, I'm now certified at ISO 27001, there's my stamp. I haven't seen any information yet that says, yeah, there's a national certification scheme or, you know, these kind of things. What I think will happen is that the ICO will pick up the standard certification schemes like 29100, 27001, and there are a few others, and allow companies to use those to show that they comply with the information security standards that are relevant within the industry. But there isn't anything that says, you know, you need to be certified by this date. What it does say is the regulations come in then, you will be expected to have met them by then, and the ICO from then can enforce the requirements as of May 2018.
Okay, super. So a question on personal data. Does personal data relating to employees come under GDPR? For example, marital status, date of birth, address?
The answer is it can be yes and no, and I know that's again another another interesting set of information. That there is the ability to opt out in terms of local ICOs, suggesting that internal data from a company doesn't fall under the GDPR. There is the option for that. I haven't seen any of that exercised yet, or any information specifically relating to it. The only exclusions that are in there at the moment is any data that is processed for household or purely domestic activities. That's the only opt-out that is given. What it does do is it makes specific reference to things like, you know, biomedical data or fingerprint or biometric data or any of these kind of things that companies may use for identification or that kind of stuff. Any sensitive data, you know, like passports or bits and pieces, absolutely should be processed for HR reasons, you know, in line with GDPR requirements. It'll be interesting to see what the ICO says and whether they exclude the data inside companies specifically, but there isn't anything at the moment that suggests that they will or they won't.
Thank you. Okay. So another question on communication. So when it comes to communication, is it sufficient to provide a clear web page that can be linked to via a small print button, for example, next to an unsubscribe button in an email?
Yeah. So in terms of the information you provide, it has to be clear and transparent. It doesn't say, there are no specific regulations that say you must provide it in 15-point text, that, you know, etc., etc. So that's left down to each of the individual businesses to decide how they communicate with the customers, what they write, how they do it. However, what they say is it needs to be clear and unambiguous. So, you know, one of the things that I would suspect that the ICO will want you to do, and I'm sure I know there's some more information going to be published within the next quarter by the working party around consent and around the communication pieces. I would expect, you know, if you're doing a contract and you're providing data, right, one of the things that the ICO is going to want to see that you've considered is, firstly, do you actually need that data for the fulfillment of that requirement? If yes, where and how do you display that? And people have got to be able to find the information. It can't be, you know, 6-point text on the, you know, right down the bottom that nobody can see because it's hanging off the bottom of the screen. Yes, you know, it absolutely can be provided, you know, on web pages and those kind of things if using electronic means, absolutely. However, it does have to be accessible and it has to be transparent and clear so that people can get to that information, they can assess whether they want to give you the data for the reasons that you state you need it. Hopefully that helps.
Yes, certainly. So we have a question around data retention. Are there any obligations to retain customer data unless customers ask their data to be removed for future legal reasons, for example?
Okay. It's probably one for the lawyers, but I'll give you some examples that I know of. Okay. So, for instance, okay, retaining data. The question you have to ask is, do you actually need that data for the fulfillment of a contractual obligation, a legal reason, or something else? Okay. So, for instance, when you take a credit card payment, okay, how long do you actually need to keep that data for? Okay, so could be 6 months, could be up to 24 months. So depending on the contract that you have with your bank, it could say you need to be able to provide the information to the bank for chargeback purposes for anywhere between 6 and 24 months. So depending on who the bank is, whether it's a Visa card or a MasterCard, depends on how long you need to keep that information. However, you don't need to keep all of that information, because actually you can defend a chargeback with the first 6 and the last 4. So effectively, you've pseudo-anonymized that data in terms of its requirements. Now, if you are somebody like, I don't know, a TV manufacturer, and you provide warranties on your TVs for 3 years, it's not unrealistic in order to expect that you're going to keep the data for the fulfillment of that warranty, so that if somebody actually comes along to claim that warranty, or you need to do a product recall or these kind of things, absolutely it's appropriate in order to keep that data in order to be able to fulfill the contractual obligation that you have with the customer. Okay. However, if you've held that data for 10 years and there is no contractual obligation, legal obligation, or consent from the customer that you may maintain that data outside of the requirements that you need it for, then you shouldn't keep the data and you should remove it. One of the big things about GDPR is about data minimization, about keeping the data in as few locations as you possibly can, keeping it to the minimum that you've got. I mean, actually making sure it's accurate. Is that data actually accurate? Having 100,000 records but only 15,000 of those are accurate, well, actually you'd be better off getting rid of the rest and only keeping the 15,000 that are accurate. So it's very much around only keep data for as long as you need it, for as long as you're contractually obligated to keep it, or if you're under particular pieces of legislation where you have to keep that data, then you have to keep it for the specified periods of time. But if you don't need it, don't keep it, and it really is that simple.
Okay, well, I'm going to take, I've got 2 final questions. So, if a customer's personal details are removed from our system, are companies able to retain marketing information or management information for research purposes? For example, customer X left us for reason Y.
So, it's a very interesting thing. So I'll deal with 2 questions there actually. One is, if somebody asks for their data to be removed, then actually, yes, you have a requirement to remove it, but also you have a requirement to tell your third parties and processors they need to remove the data as well. Okay, so that's one thing I forgot to mention earlier, so apologies. Second thing is, depending on what you're doing with the data and depending on what you're maintaining and depending on what you've told the customer, the data subject, if you are using it for things like scientific research, archiving, historical information, and purposes that relate to the activities of the controller, I believe it says, then yes, and those and the processing that you are going to do with it is in line with and not outside of the consent that you've achieved, then yes, you may use it for things like scientific purposes, research purposes, archiving, historical access, and that kind of stuff. Okay, so there are very, very specific conditions that you would need to meet in order to do that. Now, I'm not a solicitor. I would say these are areas that I am sure are going to be challenged in court, probably significantly over the next 5 or so years. I believe that there is also some further information coming out from the ICO's office as well in relation to this area, and keep an eye out for that. But the answer is yes, if you've achieved the right consent and you meet the predefined criteria that are within the GDPR.
Okay, last question. So I'm aware that we are, people have been so interested, we're now running well over time. Are there any clear guidelines on the definition of personal data compared to corporate data if someone does business to business or business to consumer selling? So what are the different definitions from B2B and B2C selling?
Yes, so it's interesting because, funnily enough, you and I were talking about this yesterday, because we had a little bit of a joke about the fact that people were opting in with their business data in order to receive marketing materials by signing up to this webinar. And Shona and I had a good laugh in relation to this yesterday. And what she reminded me about was things like distance selling regulations and other requirements under the GDPR that the ICO may or may not change in terms of e-privacy requirements and this kind of stuff. This is one of the things that bothers me with all of these regulations. Okay, they become more and more complex over time. They become more and more fragmented over time, and it becomes very, very difficult for companies to actually say, do you know what? Do I need to comply or not? Do I have to meet these requirements or not? The GDPR is quite clear in terms of what it considers personal data and what it doesn't. It also is very, very clear in terms of what it considers sensitive data. So, personal data is anything where you can identify a naturalized living person, and that's a living person, not a not somebody that's died, and I'm sure there's going to be some cases around that when it comes to processing things like probates and wills and all sorts of stuff, and I think there's going to be some interesting legal challenges there. Anything that will cause damage or harm to a subject, to a data subject, is covered. Specialist data or high-risk data, or whatever you wish to call it, is also covered around things like gender, race, sexual orientation, biometric data, and others as well. It's starting to get very difficult for companies to know whether they should or whether they shouldn't comply. The answer is, do you comply with the Data Protection Act today? If so, you will be required to comply with the GDPR tomorrow. Okay, and that's the basic advice. If you're in any doubt, ask the ICO. So for companies like mine, specifically, I'm not under the Data Protection Act at the moment because I don't process customer data, I process business-to-business data. However, when the GDPR comes along, I will be under the GDPR for specifically around the activities of forensic investigation and those kind of things for a lot of the widespread data that I hold. I will also process, internal HR data in line with GDPR as well, until I get guidance from the ICO that says it's specifically in or it's specifically out. The answer is, you're going to have to watch this space, unfortunately, for the ICO to come out and decide which other regulations in terms of e-privacy and these kind of things it's going to update. So a bit of a cop-out, unfortunately. I apologise. but some of it is going to be wait and see.
Okay, so I do have one more person that need to jump another question, so we'll go through it very quickly. And so this is the last question, everyone. So if someone subscribed to receive information from our company 10 years ago and they can't prove their subscription, are they expected to go back to those people for fresh consent? And I think I know what the answer to that one is based on the first question you were asked, but if you could just clarify on that one. So in cases where you can't prove subscriptions.
If you can't prove that you have consent, you don't have consent, is what I am told by my learned legal colleagues and my own reading of the GDPR. It may be possible to speak to the ICO and have that conversation with them, depending on how much data you've got, how material it is to your business, and those kind of things. I know there are certain industries specifically that really don't want to communicate with their customers. In terms of broadband providers, i.e., I know that I've worked for a few, and I think the last stat was, if they actually spoke to their customers, 90% of them would leave. Therefore, they kind of don't want to speak to them unless they absolutely have to, because they've got a chance of cancellation. So, what I would say is, if you can't prove you've got consent, the likelihood is you haven't got consent. If it is a game changer for your business, absolutely speak to the ICO. Well, speak to your legal counsel first, and then speak to the ICO if you need to, in order to get some very, very specific advice on that case.
Okay, so thank you everyone for joining us. I hope you found today's session useful. Thank you massively to Steve for staying so long on the call, answering so many good questions. Just to clarify, we have recorded today's session, and I have been annotating the answers to most of your questions in writing as well, where I've been summarising those. So those will be made available alongside the slides and the webinar recording. It just remains for me to thank everyone for their time. Hope that everyone found it useful, and I hope to welcome you to other future GDPR updates over the coming weeks. Thank you very much, everyone.